All right, welcome everyone to another deep dive. Today we're going deep on Spanish property law.
Oh, exciting.
Yeah, really interesting stuff. We're going to be looking at a whole bunch of legal aspects of property rights in Spain,
Hmm.
how ownership can be shared, the role of the property registry, that kind of thing.
Absolutely, yeah.
We've got a ton of sources for this one. We've got Derecho de la Propiedad, we've got El Registro de la Propiedad, Los Derechos Reales, a few more. We're not going to list them all. But
Right.
the goal here is to really get down to the fundamentals
Yeah,
of what it means to own property in Spain, the legal side of things,
exactly.
how it actually works in practice,
Yeah.
and hopefully a few kind of aha moments along the way for our listeners without getting too bogged down in all the legal jargon.
Right. Trying to make it as accessible as possible, but still give people that real in-depth understanding.
Absolutely. So let's start right at the beginning. Like, what even is property in the legal sense?
Yeah.
In Spain, they use the term derecho de propiedad, right, of property. And our sources define it as essentially complete legal power over a thing.
Oh, wow.
Like total control.
Okay.
You get to decide what happens with it. And it's meant to serve the owner's individual interests.
Hmm.
But, and this is interesting, it also has this idea of fulfilling a social function.
Ah, interesting. So it's not just about individual rights, but there's a societal aspect to it as well.
That's right, yeah. It's about how your ownership fits into the needs of the broader community.
Right, right. That's a really interesting concept.
And with this right comes some pretty specific powers.
Okay.
Legally, you have the freedom to dispose of your property however you want.
So you can sell it, give it away.
Exactly. Put
Yeah.
limits on it, whatever you want. And materially, you can use it, enjoy it, lease it out,
Mm-hmm.
get income from it, and maybe most importantly, you have the power to exclude others from it.
Ah, so that's the whole keep out sign kind of thing.
Yeah, that's the right to say, this is mine, you can't use it unless I say so.
Right. So there's a strong sense of individual control there.
Absolutely, yeah. They actually describe it as an absolute right in that sense. And this power, it's what they call a subjective right. It belongs to the owner over this specific object.
Okay, so that makes sense.
And this, right, it generally applies to any tangible thing that can be owned, like, a car, a house.
Right. The things you can actually touch and possess.
Exactly. But it also applies to things that are, maybe not physically tangible, but can be identified.
Oh, interesting.
So think like intellectual property, copyrights, patents, that kind of thing.
Okay, so it covers a really broad range.
Yeah, it's a pretty fundamental concept. And
Right.
this right, it's not just, floating out there in the ether. It's actually protected by the Spanish Constitution.
Oh, wow. So it's like really enshrined in their legal system.
Exactly. Article 33.1 specifically recognizes the right to private property
Hmm?
and inheritance as a fundamental right,
Okay.
right up there with, freedom of speech, freedom of assembly.
Wow, that's pretty powerful.
It is, yeah. And Article 33.3 goes even further. It says that no one can be deprived of their property
Mm-hmm.
unless it's for a really good reason, like for public use, building a road or something.
Right, right. Like eminent domain.
Exactly. And even then, they have to be properly compensated.
So there are safeguards in place.
Yeah, they take this right very seriously. But there's another side to this constitutional protection,
Okay.
which brings us back to that idea of the social function of property.
Oh, right. So there's a balance, isn't there?
Yeah, it's not just about the individual. Article 128 says that all the wealth of the country, no matter who owns it,
Mm.
is subordinate to the general interest.
So it's like your ownership has to take into account the well-being of society as a whole.
Right. And Article 47 is really interesting. It talks about the right to decent housing
Okay.
and says that the government has a responsibility to make sure people have access to that and to regulate land use so it doesn't get out of control.
Right, to prevent things like excessive speculation.
Right. Exactly. And even to make sure the community benefits from any increases in property value.
So it's like a really holistic view of property. It's not just about individual profit.
No, it's definitely not. So, big picture, it seems like Spanish law really emphasizes this balance between individual ownership and the needs of society as a whole.
That's really interesting.
Yeah. Now, who can actually own property in Spain?
Mm-hmm.
Article 38 of the Civil Code says it's pretty straightforward, both individuals and legal entities.
Oh, so like companies and organizations can own property too.
That's right. They can acquire and possess pretty much any kind of goods, with some limits, of course.
Right. There are always going to be some limits.
Yeah, like, for example, there are rules about legal capacity to act.
Ah, so you have to be like of sound mind and able to make decisions for yourself.
Exactly. which, for adults, that's generally assumed.
Okay, makes sense.
And as we talked about before, the usual object of ownership is something tangible,
Right, something you can physically hold,
but the law makes comparisons for things that are intangible.
like intellectual property again.
Yeah, exactly. It recognizes that you can have a form of control, even
Uh-huh.
if you can't physically possess something.
Right.
And we should also mention there's a big distinction between public and private property.
Yeah, that's important.
Things like roads, natural resources, that kind of thing, those are public, and there are different rules for those.
So, okay, we know who can own property. But how do you actually go about getting it in the first place?
Well, Article 609 of the Civil Code, it lays out a few ways.
Okay.
One is occupation. Basically, if you find something that's unclaimed,
Mm-hmm.
you can take ownership of it.
Like finding a lost treasure or something?
Well, maybe not quite that dramatic.
Right.
But yeah, that's the general idea. You can also get property by law.
So, like through court judgments or inheritance?
Exactly, yeah. Inheritance, either through a will or if there isn't one. Then there's donation, obviously.
Mm-hmm.
And then contracts combined with what they call tradition.
Okay, I'm not familiar with that term. What does that mean?
We'll get into that in more detail later.
Right.
But basically, it involves the actual delivery of the property.
Ah,
And lastly, there's what they call prescription, or usicapium.
usicapion.
Yeah, it's a bit complicated, but essentially, you can gain ownership through continuous possession over a long period of time.
Wow, so even if you didn't originally own it.
Yeah, if you've been using it openly and exclusively for long enough.
Interesting. That seems like it could get pretty tricky.
It can, yeah. Now, back to these ways of getting property,
Okay.
they make a distinction between what they call original and derivative acquisition.
Oh, what's the difference there?
Original is when you acquire something independently of any previous owner.
So like the occupation example, finding something unclaimed.
Yeah. Or usicapion. Derivative is when you're getting a right that someone else already had.
Okay, so like inheritance or buying something.
Exactly. And of course, these acquisitions, they can be either onerous, meaning you pay for it, or gratuitous, meaning it's a gift.
Right, so buying a house versus inheriting one.
Exactly. Now let's dive into that contracts through tradition thing.
Yeah, I'm curious about that.
It's based on what they call the title and mode theory.
Title and mode. Okay, break that down for me.
So the title, or titulo in
Yeah.
Spanish,
Mm-hmm.
is the legal basis for the transfer.
Like the contract.
Exactly. The contract, the deed, whatever establishes the intention to transfer the right.
Okay, so that makes sense.
But having the title alone
Yeah.
doesn't actually make you the owner.
Oh, really? So what else is needed?
That's where the mode or modo comes in.
Oh.
It's the actual act of delivering the property with the intention of transferring ownership.
Ah, so it's like two sides of the same coin.
Exactly. You need both the legal agreement, the title,
Mm-hmm.
and the physical act of delivery, the mode.
To actually complete the transfer.
That's right. For example, you could have a perfectly valid contract to buy a house,
Yeah.
but until the keys are handed over,
You don't actually own it.
you don't legally own it, no. And the reverse is also true. Just giving someone a house
Mm-hmm.
without a valid contract doesn't make them the owner either.
Oh, interesting. So they might have possession, but not actual ownership.
Exactly. It's a really important distinction.
It is, yeah.
Now, this tradition, this delivery, it can happen in a few different ways.
Okay.
The most obvious one is what they call tradition real.
Real tradition.
Yeah, it's the actual physical handing over of the thing.
So literally giving someone the keys to the house.
Yeah, exactly. But there's also tradition symbolica.
Symbolic tradition. What's that?
This is when you transfer ownership by delivering something that represents the property.
Oh, okay.
So instead of physically handing over, say, a huge piece of land,
Yeah.
you may hand over the title deeds.
Ah, so it symbolizes the transfer of ownership.
Exactly.
Yeah.
And the law recognizes this as valid.
Interesting.
Another type is acuerdo de las partes, agreement of the parties.
Mhm.
This is where the transfer happens just through a mutual agreement.
Okay, so no physical handover needed.
Right. There are two main scenarios for this. Traditio brevi manu.
Brevi manu.
Yeah, it's Latin. Basically, it means the acquirer already has the thing in their possession.
Oh, okay.
So, like, let's say someone is renting a house and then they decide to buy it.
Mm.
They already have possession, so they don't need to physically hand it back and forth.
Right. It just changes the legal basis of their possession.
Exactly. The opposite of that is constituto possessorio.
That's a mouthful.
It is, yeah. In this case, the seller keeps physical possession,
Hmm.
but legally recognizes that someone else now owns it.
So like if they sell the house but stay on as a renter.
Exactly, yeah. Then there's what they call tradition instrumental.
Instrumental tradition.
This is where the delivery happens through the granting of a public deed.
Ah.
Article 1462 of the Civil Code says that signing that public deed in front of a notary is basically equivalent to physically handing over the property.
Okay, that makes things a lot easier.
Yeah, it's a very formal way to do it.
Right.
Unless the deed itself says otherwise.
And this applies to both movable and immovable property.
That's right. And lastly, there's tradición de bienes incorporables.
So for intangible things, like intellectual property.
Exactly. This usually happens by delivering the documents that show ownership, or by the new owner just starting to use the right with the previous owner's permission.
Makes sense.
Okay, so that's a whole lot about how property is actually transferred.
Yeah, we've covered a lot of ground there.
But what about the property registry? Where does that fit in?
Right, because we hear a lot about that.
We do, yeah. Real rights over property can be registered there. But it's important to understand that registration isn't what creates the ownership, right?
Well, okay. So it's not like registering a car where you actually become the owner by registering it.
No, not in Spain. The ownership is transferred through the title and the mode.
Right, those two things we just talked about.
Exactly. Registration is more about making it public and giving it legal certainty.
So it's like proof of ownership.
Yeah.
In a way.
That's right. You take your title once the tradition has happened and you register it.
To show the world, hey, this is mine now.
Yeah, exactly. And it makes it much harder for anyone to challenge your ownership later on.
That's good to know.
Now, there is one interesting legal presumption that comes with registration.
Okay.
Article 38 of the mortgage law says that if you're registered as the owner of a property, the law assumes that the tradition has already taken place.
So they basically assume you've gone through the whole process properly.
That's right. It gives you a very strong legal position.
Interesting.
But what happens if there's a problem with the underlying contract, the title?
Like what kind of problem?
Let's say it's later found to be invalid or ineffective for some reason.
Oh, okay.
Well, then the tradition might be affected too. Our sources say that if the contract is annulled or rescinded, the person who acquired the property, they might be entitled to compensation. And if the property was delivered based on a contract that never existed, then they might have to give it back.
Because there was no legal basis for the transfer.
Exactly. But it gets a bit more complicated if someone else has bought the property in the meantime.
Oh, right. Like a subsequent buyer.
Yeah. But there's a provision in the mortgage law to protect them.
Right.
If someone buys a property in good faith.
So they genuinely believe the seller is the rightful owner.
Right. And they pay a fair price, and the seller's listed in the registry, and then they register their own purchase.
Yeah.
Well, they're protected even if it turns out the original title was faulty.
Wow. That's good protection for buyers.
It is, yeah. It's all about maintaining the reliability of the registry.
Okay, that makes sense.
Now, we've talked about how you get property,
Right.
but how do you lose it?
Good question. Besides just selling it, I mean.
Well, some ways are pretty obvious, like if the property is destroyed or if it becomes legally impossible to own it for some reason.
Right, if it goes out of commerce, as they say.
Exactly. You can also voluntarily renounce your ownership.
You can just say, I don't want it anymore.
Well, for real estate, it's not quite that simple.
Oh.
You have to actually abandon it as well. Like, stop possessing it.
So just saying it isn't enough, you have to actually leave.
That's right. And if a property is truly abandoned, it ends up belonging to the state.
Interesting.
Then there's forced expropriation.
Ah, that's where the government takes your property.
Right, but only if there's a justified reason of public interest, like building a new highway or something.
And they have to compensate you.
Absolutely. And there's a whole legal process they have to follow.
Okay.
And the effect of expropriation, it depends what happens to the property afterwards. If it becomes public, your ownership is extinguished. But if they give it to someone else...
It's more like a forced sale.
Yeah, exactly. Another way to lose property is through what's called extinctive prescription.
Extinctive?
Yeah, it means you lose your right if you don't actively exercise it for a long time.
How long are we talking?
30 years for real estate.
Wow, that's a long time.
It is, yeah. And it's not just about not using the property. You also have to be taking steps to defend your ownership if it's challenged.
So you can't just ignore it for 30 years and expect to still own it.
No, you have to be actively involved. And that brings us back to usucapion.
Ah, right, the other side of the coin.
Exactly. If someone else possesses your property for that long...
They could actually become the owner.
It could, yeah, under the right conditions.
Wow, that's pretty wild.
It is, yeah. There are a few other ways to lose property, like caducity.
Caducity?
It basically means a right expires,
Oh,
like a lease running out, for example.
right, right.
Or consolidation, where a smaller right merges into full ownership.
Mhm.
And of course, if the owner dies and the property was tied to their lifetime.
Then the right would end.
Exactly. All right, let's talk about situations where there's more than one owner.
Oh, yeah, shared ownership, that's common.
It is, yeah. In Spain, they call this plurality of owners.
Okay.
And the main concept here is comunidad de bien.
Comunidad de bienes.
Yeah, it's basically co-ownership, where a property is owned by several people pro indiviso.
Pro indiviso, meaning...
It means it's undivided. It's not split up into separate pieces.
Okay, so they all own the whole thing together.
Exactly. And the rules for this type of co-ownership,
Yeah.
they're mainly governed by any agreements the co-owners make.
So they can set their own terms.
They can, yeah. But if there aren't any agreements, then the civil code kicks in.
Right, so there's a default set of rules.
That's right. Now, it's important to distinguish this from copropiedad.
Copropiedad, I thought that was the same thing.
No, copropiedad is more specific. It only applies to the co-ownership of tangible things.
Ah, so things you can physically touch.
Exactly. Comunidad de bienes is broader.
Mhm.
It can apply to any kind of right that can be jointly owned.
Oh, interesting.
So, like, if you and I jointly own a debt that someone owes us,
Okay.
that would be comunidad de bienes, but not necessarily copropiedad.
Right, because it's not a physical thing.
Exactly. Or if we inherit an estate together before it's divided up, that would also be comunidad de bienes.
Interesting. So it's a more flexible concept.
It is, yeah. Now, our sources talk about two historical models of co-ownership.
Okay.
The Roman model, which is kind of individualistic.
Mm-hmm.
Each owner has a specific share, even if it's not physically divided.
Right.
And the Germanic model, which is more collective.
So the focus is on the group as a whole.
Exactly. The Spanish civil code actually follows the Roman model.
So it's more about individual rights within the shared ownership.
That's right, yeah. Now, there are a few key principles that govern comunidad de bienes.
Okay.
First, private autonomy. This means the agreements the owners make are the main rules.
So they have a lot of freedom to decide how things work.
They do, yeah. Then there's proportionality.
Mm-hmm.
Everyone shares in the benefits and burdens based on their share.
Fair enough.
And unless there's proof otherwise, the shares are assumed to be equal.
Okay.
There's also a democratic principle.
Ah, so decisions are made by majority vote.
Sort of, yeah. The majority is based on the value of the shares.
So it's not just about how many people vote.
No, it's weighted. And lastly, there's individual liberty.
Meaning?
Each owner retains some individual rights, like the right to demand division of the property.
So they can force a split.
They can, yeah. Or they can renounce their share if they want.
Interesting. So there's a lot of flexibility built into the system.
There is, yeah. Now let's talk about the specific rights and obligations that come with comunidad de bienes.
Mm-hmm.
First, in relation to the common property itself.
Yeah.
Each owner can use it,
Okay.
as long as they don't harm the community's interest.
Makes sense.
They share the benefits and the burdens proportionally,
Right.
and decisions about administration are made by a majority vote based on shares.
So the bigger your share, the more weight your vote carries.
Exactly. But for big changes, like selling the whole property,
Yeah.
everyone has to agree.
Unanimous consent.
That's right. And any owner can take legal action to defend the property.
Oh, interesting.
Like one owner could bring a claim to recover possession
Okay.
for the benefit of all the co-owners.
Makes sense. And what about the right to demand division?
Right. So any owner can ask for the property to be split up,
Mm-hmm.
but there are some limits.
Like what?
Well, they can all agree not to divide for a period of time,
Okay.
up to 10 years, and they can renew that.
Right.
And obviously, they can't divide it if it would make the property unusable.
Yeah, that wouldn't make much sense.
No. Or if it's physically impossible to divide,
Mm-hmm.
like, a single painting or something.
Right, right.
In those cases, they usually just sell it and split the proceeds.
Okay, that's fair.
Now, each co-owner also has individual rights related to their own share.
Mm-hmm.
They own that share completely, can sell it, mortgage it, whatever.
Okay.
But they also have a right of retracto.
Retracto.
Yeah, it's like a right of first refusal.
Ah, I've heard of that.
If another co-owner wants to sell their share to someone outside the group,
Yeah.
the other owners have the right to buy it instead.
So it keeps the ownership within the group.
Exactly. Now, how does comunidad de bienes end?
Mm-hmm.
Well, one way is if one of the owners renounces their share.
Okay.
but that only affects their individual ownership.
Right.
It can also end if someone loses their ownership through prescription.
So, like, if someone else acquires it through Eusebia.
Yeah, that's right. Or through consolidation.
Consolidation.
This is where one person ends up owning all the shares.
Ah, so they become the sole owner.
Exactly.
Yeah.
And of course, it ends if the property itself is destroyed or if they all agree to divide it up.
Right.
Our sources also mention a few special types of comunidad,
Okay.
like Sociedad de Gananciales, which is the default property regime for married couples in some parts of Spain,
Interesting.
and hereditary communities, which happen during the administration of an estate, and unincorporated associations. These have their own specific rules. All right, let's move on to a very specific type of co-ownership. Propiedad horizontal.
Propiedad horizontal. That sounds familiar.
It's the legal framework for apartment buildings.
Oh, okay.
Article 396 of the Civil Code defines it as the coexistence of two types of ownership.
Two types.
Yeah. You have exclusive ownership of your individual unit.
Like your apartment.
Exactly. And then you have co-ownership of the common elements of the building.
So the hallways, the elevator, that kind of thing.
Exactly. This system was further developed by the Horizontal Property Law of 1960.
Okay.
So the key idea here is that you own your apartment outright, but you also own a share of the shared parts of the building.
Right. And how is this propiedad horizontal actually set up?
Well, it can happen in a few ways.
Okay.
The original owner of a building can decide to divide it into units,
Mm-hmm.
or a building that's already co-owned can be divided this way,
Right.
or, and this is very common, a developer can build a building
Yeah.
with the intention that it will be governed by horizontal property rules.
Okay, so it's built that way from the start.
Exactly. Now, the legal recognition of this regime, it comes with something called the Titulo Constitutivo.
Titolo constitutivo. What is that exactly?
It's a public deed, basically a very formal document
Okay.
that establishes the horizontal property and defines the units.
So it's like the building's constitution, in a way.
That's a good way to put it, yeah.
And this document, it has to be registered.
It does, yeah, in the
Yeah.
property registry. That makes it official and protects the owner's rights.
Makes sense. And what kind of information does this Titulo Constitutivo need to include?
Article 5 of the Horizontal Property Law lays it all out.
Okay.
It needs a description of the whole property, including all the legal details, a description of the common services and installations,
Right.
and a detailed description of each individual unit.
So everyone knows exactly what they're getting.
Exactly. Now, in addition to the Titulo Constitutivo, buildings usually have what they call estatutos, statutes. These lay out the rules for how things are run.
Like the bylaws of a homeowners association.
Exactly, yeah.
Right.
How expenses are shared, how decisions are made, and if these statutes are registered in the property registry,
Yeah.
they become binding on everyone.
This is important to get those right.
It is, yeah. There are also internal regulations.
Internal regulations.
Yeah, these are more about the day-to-day stuff, like how to use the common areas, that kind of thing.
Right, more practical matters.
Exactly. Now, within Propiedad horizontal, you've got two main types of elements.
Okay.
The private elements, which are the individual units, and the common elements.
Right.
Article 396 of the Civil Code actually gives a very long list of what counts as common.
Oh, wow. So it's not just the obvious things.
No, it's pretty comprehensive. The land, the foundations, the roof, the structural walls,
Okay.
entrances, staircases, hallways, courtyards,
That makes sense.
elevators, all the installations for utilities,
Mm-hmm.
even collective antennas and security systems.
So basically, anything that's necessary for the building to function.
Yeah, and for everyone to use and enjoy their own units.
Okay, that makes sense.
And then there's the quota.
Quota.
Yeah, it's basically a percentage share that's assigned to each unit.
Oh, okay.
It represents that unit's share of the total value of the property,
Right.
and it determines how much each owner contributes to expenses.
Ah, so the bigger your apartment, the more you pay.
Exactly, yeah. And it also affects their voting power in the owners association.
Okay.
Now, if an owner makes improvements to their unit,
Yeah.
that doesn't automatically change their quota.
So it's fixed based on the initial value.
Right. It can only be changed through specific legal procedures.
Okay.
Now, let's talk about the rights and obligations of the owners.